Supreme Court of India Chandra Pratap Singh vs State of MP decided on October 9, 2023 SCC Online SC 1277 Facts of the case, 17 accused prosecuted for the offence of triple murder, trial court acquitted accused numbers 3 to 8, 10, 13, 15 and 17. The trial court convicted accused numbers 2, 9, 11, 12, and 16 for the offence punishable under Section 302, read with Sections 148 and 149 and Section 201 of IPC. Accused numbers 1 and 14 were convicted for the offence punishable under Section 302, read with Section 148 of IPC. The trial court did not frame a charge against any accused for the offence punishable under Section 302, read with Section 34 of IPC. The High Court acquitted accused numbers 9, 11 and 12. High Court partly allowed the appeal of the present appellant and accused numbers 1, 14 and 16 by substituting their conviction under Section 302, read with Sections 148 and or 149 of IPC with Section 302, read with Section 34 of IPC. The appellant's conviction for the offence punishable under Section 201 of IPC was maintained. Findings of the court: High Court has committed illegality by deciding the appeal against the conviction preferred by the appellant without hearing the appellant or his advocate. It was necessary for the appellate court to put the appellant to notice that it intended to convict him with the aid of Section 34 of IPC, for which a charge was not framed. The court can give the notice of the proposed alteration or addition of the charge even by orally informing the accused or his advocate when the appeal is being heard. Appellant's advocate was absent on the date of the hearing. Therefore, there was no occasion for the High Court to put the advocate for the appellant to the notice that the charge under Section 302, read with Sections 148 and or 149 of IPC was proposed to be altered to a charge under Section 302, read with Section 34 of IPC. Therefore, grave prejudice has been caused to the appellant by altering the charge without giving any notice to the appellant or his advocate about the charge. The reason is that there was no opportunity available to the accused to argue that there was no evidence on record to prove the existence of common intention, which is the necessary ingredient of Section 34 of IPC. No finding is recorded in terms of subsection 4 of Section 216 of CRPC that the proposed alteration of the charge will not prejudice the accused and his defense. High Court confirmed the conviction of only 4 and acquitted all others. The offense of unlawful assembly was not made out, and therefore, the offenses under Sections 148 and 149 were not made out. There is no evidence of the presence of common intention. There is no overt act attributed to the appellant by any prosecution witness in the assault on deceased Uma Prasad. It is difficult to infer a prior meeting of minds in this case. There is no material to prove the existence of common intention, which is the necessary ingredient of Section 34 of IPC. The evidence of 2 eyewitnesses, PW1 and PW2, is very consistent on the role played by the appellant in dragging the dead body of the deceased and throwing the same into a well. There is hardly any cross-examination on this aspect of both PW1 and PW2. Therefore, there is every justification for convicting the appellant for the offense punishable under Section 201 of IPC of causing the disappearance of the evidence of the crime. The appeal partly succeeds. Set aside the appellant's conviction for the offense punishable under Section 302, read with Section 34 of IPC. Appellant's conviction for the offense punishable under Section 201 of IPC is confirmed.